Caveat emptor. The term caveat emptor is derived from the Latin word which means let the buyer beware. The implication of this term in law is that the buyer be cautious while purchasing the goods or product. He should be aware of the quality as well as the pros and cons of the product. Once the sale is complete, the buyer cannot claim against the seller or raise any objection and demand any damage or compensation, nor return the product. The objective behind this maxim is that the buyer should use his prudence, skill to judge the product before buying. The concept of this maxim originates from the notion that the buyer should use his judging mind to the usefulness, fitness and quality of the product. So after purchasing, no right is left in the hand of the purchaser. The maxim found its base in the English legal system in Sales of Goods Act 1893. The laws of this act was bent towards the seller or vendors. The maxim caveat emptor was firstly encountered in Priest versus Lust. Thereafter, the English court started providing exemption in certain situations where caveat emptor shifted to caveat vendita. In India, the caveat emptor is explained in section 16 of the Sales of Goods Act 1930. Let us now discuss the exceptions of rule of caveat emptor. There are a number of exceptions when the responsibility of the buyer or the rule of caveat emptor does not work. Let us discuss some of them one by one. A. In case of sale by description. If the seller or vendor states the qualities of the product on sale, that is, he is selling the product by describing the nature and features of the product, and after the purchase the product does not match with the description, that is, with the nature and features of the product, then the buyer is not at all responsible and the rule of caveat emptor will not be effective. B. By misrepresentation or fraud. If the seller sells his product by inducing fraudulent acts, that is, he brought the confidence of the buyer by fraud or misrepresentation, then the rule of caveat emptor will not apply. C. Sale by sample. If the vendor shows a particular quality of good or product as sample for satisfying the buyer, and on supply sells a different quality, then the seller is not protected under rule of caveat emptor. D. Buyer relies on the seller. If the buyer discloses to the seller that he needs a particular type or quality of product for a particular purpose, thereby he is depending on the prudence of the seller to supply him such quality of product which goes with the buyer's need or purpose. And if the seller sells a different quality of product which does not fit to the buyer's need or usage, then the seller is not covered by the rule of caveat emptor. E. Merchantable quality. Merchantable quality means a product having passed the market standards. In some cases, the product must have resale value. If the goods sold by the vendor are not of merchantable quality, then the vendor is not protected by rule of caveat emptor. But if the buyer have the opportunity to check the quality, then the vendor is not responsible. F. Latent defects. Defects are of two types, apparent to latent. Apparent defects are those which can be identified in ordinary course by or bare eyes. Latent defects are those which comes into picture when one uses it. That is the hidden defects. In all cases, it is not possible for the buyer to check the inherent or latent defects of the product. In such scenario, if such defects found after the sale, the vendor cannot take the benefit of the rule of caveat emptor. G. Fitness of the product. It is implied that when a buyer purchasing a product, such product is fit for that particular purpose. If the product does not stand with the fitness of the purpose, then the buyer is not responsible and the vendor is not covered by the rule of caveat emptor. Example, a refrigerator will cool, a spraying machine will spray. If this product does not perform its normal function, then it is not fit and the buyer is not responsible. There are a number of cases fought under this doctrine in India. Some of them are A. Dorab Ali Khan versus Abdul Aziz, Calcutta High Court, 1878. 2. Commissioner of Customs versus Afloat Textiles India Private Limited, Supreme Court, 2009. 3. Raghava Menon versus Kullappan Nair, Kerala High Court, 1962. Messrs. Imami Limited versus Nikhil Jain, Delhi Consumer State Commission, 2017. The objective behind this rule is that the buyer should not be ignorant of what he is purchasing from another.